lead respondent, you are the lead respondent. So obviously we'll just sort of assume we've heard from the other side. They finish speaking, and then if you just want to get going when you're ready in your own time.
Okay, that's great. Thank you, Your Lordship. So if I may please, Your Lordship, I am Leanne Wilson and I am lead counsel for the respondent. In this case for the defence, in Hingston's refusal is to seek medical treatment and his reasons for doing so. Had Mr Andrews had not have stabbed Mr Hingston, he wouldn't have had to seek medical assistance, this leading to his death. I, the respondent, would like to submit the eggshell skull rule on this case. The eggshell skull rule, also known as the thin skull rule, says that the frailty, weakness, sensitivity or feebleness of a victim cannot be used as a defence. This leading Mr Justice into directing the jury on the Crown and Blue case of 1975, stating that the initial stab wound could be regarded as the operative cause of Hingston's death, notwithstanding Hingston's refusal to seek medical treatment and his reasons for doing so. I, the respondent, agree with this. The defence claiming that Mr Hingston has died as a result of not seeking medical assistance and not the stab wound itself. The appeal is opposed on the following grounds. In the Crown and Blue case from 1975, please refer to my page 1 of my bundle, which is the Crown and Blue.
Yes.
In which the defendant, who broke into the victim's home asking for sexual advances. The victim rejected the sexual advances, and the defendant then went on to stab the victim numerous times, one of these piercing her lung. The victim sought medical assistance, in which she was advised she would need surgery, but before this surgery could be carried out, she was advised she would need a blood transfusion. Due to the victim being a Jehovah's Witness, declined to have this done. The surgeon did then advise the victim if she weren't to have the blood transfusion, she would die of her injuries. She still declined to have the blood transfusion and later died the following day. The eggshell rule was applied and the defendant was sentenced to murder as a result of her injuries, which were made by the defendant. You must take your victim as you find them. In my next submission, Your Lordship, I would like you to turn to my next case, in which is Crown and Holland of 1841. Two inmates got into a fight in a prison, and one defendant stabbed the victim numerous times, one leading to a cut on his finger. The victim was taken to hospital, where medical staff advised him he would need the finger amputating. The victim declined to have his finger amputated and then went back to the hospital numerous times to have the wound attended to. Later, the victim deteriorated and the finger was later amputated, but this was too late and the victim died of his injuries. The eggshell rule was also applied in this case and the defendant was charged with murder. If I can be of any more assistance, Your Lordship.
Yes, Counsel. If I can take you back to, well, I say take you back to Blau, also Holland as well, really. You've stated in your skeleton argument that you've mentioned the idea in Blau that the victim had a valid reason to refuse medical treatment.
That's correct.
Could we not say that in this situation the reason is invalid?
I think it's up to one person's belief. If the victim didn't want to be attended by female medical staff, maybe he may have received medical assistance if he was guaranteed that male staff would attend to his wounds.
But I mean, essentially, are we not in a situation where the victims' beliefs are essentially determining the outcome for the defendant, and are we not in danger of approving those beliefs by not taking any account of them?
But had Mr. Andrews not have stabbed Mr. Hingston, he wouldn't needed the medical assistance in the first place. He only needed that medical attention due to Mr. Andrews stabbing the victim.
I see, thank you, yes. And if I may just ask you a further question on the Holland case in particular.
Yeah.
Could it be argued that the Holland case is too outdated to be of any application today? We are talking about the best part of 200 years since it was decided.
It was argued in the Crown and Blue case that it was outdated in the Crown and Holland, but it was eventually seen as good law.
I see. Thank you very much, Councillor. I don't have any further questions.
Okay, well, thank you for your time.
Thank you. Okay, brilliant.